No civilized person wants to live in a society without a lot of privacy in it.
Supreme Court nominee Robert Bork's 1987 confirmation hearings changed everything, maybe forever, according to lawyer and Supreme Court blogger Tom Goldstein, because they legitimized the scorched-earth ideological wars that have since become the norm. After the Senate rejected Bork, President Reagan turned to a 41-year-old judge named Douglas H. Ginsburg, a recent appointee to the Court of Appeals for D.C., who, unlike Bork, didn't have a long judicial record for the Senate to pick over. It wasn't to be.
Yesterday, the nominee for the U.S. Supreme Court admitted he smoked marijuana once in the 1960s and a few times in the 70s. That led to talk of withdrawal.
I have today asked President Reagan not to forward my nomination to the Supreme Court.
Ginsburg withdrew his name for consideration, and Justice Anthony Kennedy ended up filling the vacancy. Over the next 3 decades, Judge Ginsburg built a reputation as one of the most influential and principled champions of originalism, a legal theory that emphasizes close adherence to the text of the law and the explicit intentions of the legislators at the time laws are passed. Now a senior judge on the D.C. Circuit Court of Appeals and a professor at George Mason University's law school, Ginsburg stars in the forthcoming PBS series, A More or Less Perfect Union, his personal exploration of the history and future of the Constitution in American life.
These documents are the charters of freedom, and freedom is what the United States is all about.
The Constitution is really perhaps the greatest secular document ever written.
We don't have a religion. We don't have an ethnicity. We have a Constitution.
It's the law of laws.
It's idiot-proof, and we have tested that over and over again.
I sat down with Ginsburg to discuss his new show and its companion book. Why the impeachment proceedings against Donald Trump are in no way a constitutional crisis, his opinions of Neil Gorsuch and Brett Kavanaugh, whether it's possible to rein in the administrative state, and why he has never regretted pulling his name for the Supreme Court 32 years ago. But Douglas Ginsburg, thanks for talking to Reason.
Glad to be here.
Let's talk about A More or Less Perfect Union, a personal exploration. This is your statement about the Constitution. What's the controlling idea or the main thread running through the series?
Well, it's that the history of the Constitution has been one of fits and starts in extending liberty to more and more people, freedoms, and protecting them. Fits and starts and occasional reversals, sometimes enormous reversals. And the liberties that are protected by our Constitution are fragile and easily lost.
What's an example of, a moment of reversal and a fragile liberty that was lost or you think is most imperiled right now?
The most extreme example of a reversal it was the Dred Scott decision, in which the Supreme Court made up a right to own slaves and made it impossible for a former slave ever to become a citizen, which could only have expedited the course toward civil war. And it was totally fanciful. I mean, when the Supreme Court has either excised provisions from the Constitution or supplemented new ones of its own making, the results are not good. The Constitution is better left as it was written. Today, we see speakers being intimidated, disinvited or shouted down on campuses, including public universities, which are subject to the Constitution. And that's a very dangerous trend.
Would you say, just speaking about the First Amendment, or which I guess, it's both the right of assembly, but then also obviously free speech, is our kind of understanding of it now, or what's imperiled, that's actually a fairly recent understanding of the First Amendment, of free speech, really kind of broad-based, going back to maybe the 50s or 60s, where, there were books that were censored, politicians could sue newspapers for defamation, things like that.
Well, the First Amendment didn't really have its debut in the Supreme Court until the First World War. And the Red Scare, the suppression through the post office of magazines on the left-wing magazines and that sort of thing. So it did start a bit awkwardly. In the first few instances, actually, the censorship was upheld. But rather quickly became the most important assurance of our democracy that we have. And it kept on growing. You're right, that even in the 50s, there were cases involving local censorship. Indeed, even later on for obscenity or pornography. But the Supreme Court has really made it now, I would say, impossible to sanction someone for speech or writing of any sort, other than possibly graphics. And I think that's a great thing.
Do you feel an added sense of urgency to all of this right now? I mean, is it because you're at a certain point in your life, or do you, that you're worried about this stuff going away, or do you think the country is actually in a perilous state?
Well, the country's always in a perilous state, or at least the Constitution is, because liberties are inherently fragile. The normal state of human beings is not to be prosperous and free the way we are. And once lost, those things are very, very hard to regain. So there have been other times in our history which were more perilous, perhaps, but it's always a concern, always should be a concern. And as I mentioned, the example of what's going on now with free speech, that's one. But our politics have similarly become censorious and divisive in a way that is not healthy for the Constitution.
You are interested in the legal doctrine called Originalism. What is that, and why is it so important?
Well, it's a very simple proposition. We were given a written Constitution, and as Chief Justice Marshall said in 1803, the virtue of that is one can hold up a law or an executive action to the Constitution and determine whether it was authorized, because all of the powers are listed there. And we have, we have, with the Supreme Court's approval, drifted very far from the Constitution we were given. The legislature, the Congress, has delegated enormous amounts of power to the executive through creating agencies that are given a very broad mandate to regulate, quote, in the public interest, close quote, to achieve clean water or clean air or whatever the goal. So they escape responsibility. They have this broad delegation, and when things are inevitably made hard for some portion of the citizenry and they want relief, they write to their congressman, and the congressman says, well, I'll intervene with the agency, I'll write them a letter. So they get the benefit of saying, I voted for clean air, and then later on, I helped you when your factory was in trouble. This is not...
So, so they're not going to the root of the issue, which is the abrogation or abnegation of responsibility by Congress to actually pass legislation that binds agencies.
So the agencies enacted in the last Congress 3,100 and some regulations that have the force of law, and the Congress passed 1/18 as many laws. So 18 out of every 19 laws was basically passed by an agency, not by democratically elected members of the Congress, not subject to bicameralism, not subject to even presidential signature.
So is originalism fundamentally about the administrative state, or is
it's certainly true that the administrative state could not exist in the way that it does if we were true to the Constitution.
I mean, you're one of the kind of scholars and, I guess both architects, but also proponents and practitioners of originalism, through your rulings on the court, as well as your writings as a law professor and scholar. When did originalism start as a school of thought, and has it been successful? Because in many ways it has been. I mean, you guys matter in legal discourse in a way that nobody was talking about this 20, 30, 40 years ago. So when did it start, and is it working?
There were earlier outcroppings among academic lawyers, but the real demarcation, I would say, was in 1985 or 1984 when Attorney General Meese, I guess 85, spoke to the American Bar Association and gave a talk called A Jurisprudence of Original Intent. And Justice Brennan answered that with an article in the Georgetown Law Review talking about a living constitution. Now, original intent was quickly realized, I think, that we don't know what people intend, we know what they wrote. And so it's an original meaning, not in the public meaning, what people understood when they ratified the Constitution. So the original meaning versus a living Constitution. What makes a Constitution living? Well, what they mean, what Justice Brennan meant, what scholars since then mean, is that it's quite adaptable by, of course, 5 out of 9 justices of the Supreme Court to meet the needs, the perceived needs of the moment. And originalism is saying adhere to the Constitution. It can be amended if the contemporary needs really cannot be met. But the principles that are there are actually enduring and are sufficient in, I think, almost every instance.
So, in one of the conversations that's going on, or problems that is going to be faced in the courts, is having to do with anti-discrimination statutes that were passed in the 60s, saying you can't discriminate against people based on gender, on religion, on race.
It actually says sex.
Okay, gender. Sex. Yeah, thank you. Yeah, well, that's important, because what I was going to say is that now, one of the issues is, should sexual orientation, which nobody was really thinking about back then, should that be covered by anti-discrimination statutes? And would that, from an originalist point of view, would that require a new law being written, or is that seen as, okay, that's kind of embedded in the original meaning of what was passed?
Well, as to whether it's covered by the current statutes, that's something that might well come before my court. Okay. I really shouldn't address that. As to whether it should be, I mean, that at worst that would require another statute. It certainly isn't a constitutional requirement. Issue.
Do you think one of the reasons why some people push back against originalism is, I mean, it really does limit the power of the government. Whether it's a bureaucracy or Congress or whatever, to just say, oh no, well, we don't have to pass a new law. We'll just start doing that. Is part of the reason why people push back on originalism is it would require people in Congress right now, on whatever the issue is, to say, yes, we should be doing this or that, and they just want to escape responsibility.
Well, certainly that's why a member of Congress would push back, because it's lovely to be able to say, I voted for clean air, and not have to take responsibility for the actual consequences. And I think there's a misconception among others, not elected officials, that that originalism would somehow leave some people unprotected by the Constitution. I mean, we're not talking about a Constitution that was never amended. We had the Civil War amendments, which protect not only the former slaves, but everyone from racial discrimination. It says persons. It doesn't say all men are created equal. It's persons. Now, that it still leaves room for the Supreme Court to say in what dimensions is equal treatment required, because things that are different that can be treated differently. But that is just not a problem with originalism.
Is originalism inherently libertarian in the sense that it restricts the power of the arbitrary power of the state, or what we might agree is the arbitrary power of the state?
Is it inherently libertarian? The framers set out to protect some liberties, and the original Constitution and the Bill of Rights that were quickly added, and the Civil War amendments and other amendments protect those liberties. And embellishing that can only diminish them.
Mm-hmm. What is your sense, in talking about the administrative state or the willingness of Congress to just say, okay, we're going to pass a law in favor of clean air. You guys go figure it out. Donald Trump, Steve Bannon, his former advisor, said famously that Donald Trump wanted to deconstruct the administrative state. And yet, at the same time, I mean, which in a way takes power away from the executive branch, because it's saying, no, Congress really is calling the shots here. At the same time that Donald Trump seems to be a critic of the administrative state, he also embodies a kind of imperial presidency. Has he been good in terms of winnowing down the administrative state?
First, let me say that the Congress, to the extent we have an imperial presidency, it's because of delegations by the Congress. President Nixon was actually within the law when he imposed wage and price controls on the entire country for a brief period of time. President Trump was within the law when he imposed tariffs. The Congress delegated these huge authorities, probably thinking they would be used only in a true emergency, which is not what's happened. That's another problem of this constant delegation of authority and escaping responsibility. Consider the Iran deal, right? When President Obama entered into this agreement with Iran. Did you hear any senators saying, wait a minute, that's a treaty, we ought to be voting on that? Right. No, I didn't. I don't recall anybody.
And that's because it's easier for them to either agree with it or nitpick or say, well, there's nothing we can do about it.
Depending on their constituency, I suppose so. Yeah. But, they didn't stand up and say, we need to vote on this one way or the other.
Do you feel, and I'm just going to make you as uncomfortable as I can. Obviously, you're very skilled at not being uncomfortable, but do you think Trump's Supreme Court picks so far, Neil Gorsuch and Brett Kavanaugh, are they good for your vision of the Constitution?
I think they are. They are likely to be. I think we will be true to the text of the Constitution. Neil was a student of mine at a course at Harvard, and Brett was my colleague for 12 years on the court. I've worked with him in a lot of things. They're both very scholarly. I think they're both committed to originalism. I certainly hope so. Justice Scalia was, although he called himself a faint-hearted originalist and did depart on an occasion or two, but that remains to be seen. How whether we have
there's that
faint-heartedness
problem,
again,
right? Of growing in when you're on the Supreme Court, right? In all sorts of weird and wonderful ways.
Well, the growing seems to be always a tropism pulling to the left, and so that's called growth by the New York Times, but it might be called decadence by someone else.
Brett Kavanaugh, as your colleague, do you have any reason to question his version of events about sexual harassment that came out in his hearing?
I have no reason to doubt that.
Yeah. Here is a process question. We want the law to be transparent and known and all of that. Do you think, as a matter of practice, Donald Trump did something that was kind of rare for presidents in that he put out a public short list of people that he was considering for the Supreme Court, independent of who's on that list or whatever? Is that a good idea or a bad idea?
As far as I know, it was the first time any presidential candidate has done that. And insofar as it informed voters about what they're getting, I can hardly think it's anything but a good idea. Presidential candidates make all sorts of promises on which they can't deliver. And one of the things a president can do is choose appointees, not just for the Supreme Court or the courts as a whole, but for the administrative agencies, for the departments that are directly in the cabinet and directly report to the president. And the more people know about what the president-elect is actually going to do, I think the more informed they're voting.
Congress is refusing to take responsibility for a lot of what it does, right?
Yes.
The impeachment process is something different than that. And again, this is independent of the particulars. We throw around the idea that there's a constitutional crisis always. I mean, that gets bandied about a lot whenever anybody feels like their vision of whatever they want America to be isn't being pursued or followed. Does the impeachment process, as it's kind of rolling out right now, does that worry you at all in terms of serious constitutional problems, or is it proceeding according to the way that it should be doing?
First of all, I say it seems that in recent years the United States is a country without problems. It has only crises. Everything is inflated into a crisis by the news media. In fact, I don't think we've had any crises in my lifetime. As for the current events, there are precedents about how this proceedings should be handled, and there's a dispute now between the parties, I guess, in the Congress as to whether those precedents are being followed or not. That's not going to be justiciable. It's not going to come before a court, and I certainly shouldn't be gratuitously opining on it.
Right.
But if it were to come before the court, again, I wouldn't speak to it because then I could have to address it in court. But it's a dispute between political branches.
Do you as somebody who is generally in favor of restraining government, and also the executive branch?
Or how about preserving liberty?
Okay, very good. It's a positive way of saying it, right? When you look at the presidents who have faced impeachment proceedings, Nixon resigned before he was technically impeached, but it was in the cards. Clinton obviously happened. Trump now, it may or may not. We don't know if it's going to actually reach fruition. Right. But the idea when President Trump says, or a president says to Congress, I'm not going to give you the information, the documents, I'm not going to cooperate with something, is that problematic?
I actually do have a case on that.
Oh, okay.
Right
So
now.
you're
7 members of the House Oversight Committee are seeking documents from an executive agency because they would reflect on the president.
right.
And
Is this the tax returns, or?
no, it has to do with the hotel.
Okay.
They want some information.
Right.
The administration has not given it. The case has been argued, and it's under consideration.
Because the Second Circuit just ruled on a case about whether or not Trump's lawyers have to turn over tax documents related to questions about funding of the 2016 campaign.
Okay.
Okay. All right. Well,
Different circuit.
You must be really hard when you don't want to order at dinner. You can just say, I might have a case that rules in that, so I'm not going to say what I want. But,
I'm not sure whether it's the Second Circuit or the state court in New York.
You're not worried that right now anything going on in America, in D.C., which is a very hyperbolic, polarized environment, there are real controversies and real disagreements about what should be being done, but nothing has risen to the level of a true constitutional crisis.
Well, that's right. And when it did, when we had President Nixon's resistance to turning over and then finally turning over the tapes, the crisis is resolved. I mean, what people are arguing about, for the most part, is about the law, right? What does the law require? As long as we're arguing about the law, we're not in a crisis, right? Because everyone's got a view, but ultimately they're trying to follow or invoke the law.
Why do you think Congress, or was there a moment where Congress just said, you know what, we're not going to do our job, we're going to push it over someplace else? Or was that a gradual and a kind of intermittent process? I guess as importantly, how do we change that?
Well, the real discontinuity occurred with the New Deal. When the Congress passed one after another regulatory statute, bringing large sectors of the economy under federal regulation. I mean, agriculture, transportation, communication, finance, transportation, and assigned all the regulation to these newly created agencies. And the Supreme Court upheld that. And so that set the precedent, and the Congress has continued to do that. In the 1970s, it created, under President Nixon, created a number of statutes that regulate not the economy, but risk. So the Consumer Product Safety Commission, the Occupational Safety and Health Act, the Mine Safety and Health Act, the Traffic Safety Act, Highway Safety Act, rather, the Environmental Protection Acts. So these are different in kind, but they're similar in that there's this huge delegation of authority. The economic regulation's been almost entirely repealed. It was realized that it was contrary to the well-being of the public. It was anti-consumer.
And that's something I've heard you speak recently about this. One of the great things about the deregulations in the 70s is that you had people like Ralph Nader and Ted Kennedy, along with kind of right-wing free market conservatives, all saying, yeah, this stuff isn't working.
Right. Yeah. I mean, basically it was academics who demonstrated it empirically. It just wasn't working. And what we have now with risk regulation is a much more challenging matter because you can't just repeal it. I mean, there are real hazards out there, and they have to be dealt with. And the question is how to do it, how best to do it. And with the environment is the classic example. The problem is, for the most part, an absence of property rights. And where the government can create property rights, the right to emit a certain quantity of pollution and no more, and those can be traded back and forth, the problem gets solved in a much more efficient way than saying you have to use this particular technology or equipment or what have you.
Are you worried in a broader sense that property rights are good, markets are good, but right now we're living in a moment where markets are held in a pretty low standing by a lot of people, partly because of the 2008 financial crisis, partly because of a resurgence of a belief in socialism, that capitalism is kind of red and tooth and claw and is a nasty business, and that we have enough wealth that we can share. Is it a bad time if markets are the solution to many risk factors, particularly environmental pollution? Is this like the worst possible time to be kind of arguing in favor of markets for remedy?
Well, it's probably the most important time to be doing so. A generation has grown up that thinks that all of this prosperity grows on trees. It doesn't. It had to be created in an environment that nurtured it, and one of economic freedom. That's the only way in which that can happen. We know that. At least those of us who have witnessed what happened with socialism, and it's happening again. It's happening in Venezuela and other places, and impoverishes and enslaves people. And young people just have not lived through that and don't seem to be studying it in a serious way. So it's important that they be rescued from that ignorance and to see that the only solution is one in which we have free markets and free people.
Thinking about the recent past, really, I mean, the end of communism, you had mentioned the argument between Ed Meese and Justice Brennan about, original intent versus a living constitution. You, of course, played a part in this history as well of a hyper-polarized kind of political environment. In 1987, you were nominated to the Supreme Court.
Well, not quite. The president said he would nominate me. I finally asked him not to do so.
Yes, okay. We'll get. But Robert Bork had been nominated, gone through a very fractious confirmation process, was ultimately voted. He was not voted in, or he was not. The vote didn't go his way. You were nominated. Or rather, your name was put forward, and then it came out that you openly admitted that you had smoked marijuana, and that caused just a kind of freak out, didn't it, in kind of the way people talked about things?
Well, very briefly, and then it turned out that a lot of members of the Senate and others came forward and said, well, I did that too, and that was a while ago, as it was for me, and it was the temper of the times, and all is forgiven.
So before we get to the larger legal framework, what does it say? Is it a good thing in American society now that the three President Clinton, Bush, and Obama all have openly admitted to various kinds of illicit drug use and whatnot, and it didn't destroy their careers. They may not have been very good presidents, but nobody was blaming it on drugs. Are we in a better place in terms of discussion of kind of lifestyle choices, drug use, things like that, than we were 35 years ago?
I don't know.
Okay.
Certainly, I certainly don't think we're at a better place in terms of so many people using drugs.
Right.
What do you mean by that? Well, apparently there are a lot of people who are using illegal drugs that are harmful to their health, and in states that have legalized marijuana for one or either for medical use or more, that's inconsistent with federal law. I don't know how an industry can grow up where the federal government could start enforcing that law any day. Seemed like a rather perilous proposition.
I think that it hurts the industry, certainly, right? Because it can be wiped out, overnight. Are you in favor of reducing federal prohibitions on things like marijuana cultivation and distribution and possession in states that have made it legal?
Well, that turns out to be a more complex question than I had thought, perhaps many years ago. My understanding is now that because marijuana has been legalized in many of the Western states, the source producers have switched to selling hard drugs, heroin in particular, because they've lost much of or at least the profit's gone out of the marijuana. Well, that's not a happy consequence. It was certainly unanticipated. No one that I know ever anticipated that. But if you look at the net consequences, you have to take that into account as well. More people being addicted to heroin, not good.
When it comes to the larger kind of social, political, legal framework or way that we talk about stuff, the Bork hearings were, some people say that was the moment where America really, politics became hyper-polarized, hyper-tribalistic, or that was the starting point. Do you agree with that?
Well, I agree with it insofar as we're talking about Supreme Court nominations that had never been handled like that before. There wasn't a hearing. A nominee wasn't called to Washington to appear before a committee until I think sometime in the 1940s. And when I think it was Justice Frankfurter came down, he sat outside the committee room, waited, and then was told he could go home. So, and that was before the era of television, of course. Yeah. But the Bork hearings really polarized the process in a way that each of the parties in turn seems to think they have to retaliate, and it just escalates. And it's become, in the most recent round, it was just, I can't imagine how it could get any worse.
But it likely will. Right?
Well,
because with each replacement, it seems like the stakes get higher and higher.
Well, people will try to think of something even worse than accusing a nominee of rape, when it turns out to be fictitious. By the way, do you know that one of the accusers said she just wanted the attention?
Yeah. So, do you withdraw? Do you regret withdrawing your name from consideration?
Not really. I've had a good career on the circuit. I've known almost all of the justices since then, most of them pretty well, and I wouldn't want the security concerns that they have. It's really unfortunate, particularly the last 20 years or 18 years, that they have to be concerned about security like that.
Do you see that as partly reflecting Congress, again, kind of withdrawing from doing what it's supposed to be doing? I mean, if Congress isn't actually passing laws, it seems the Supreme Court becomes more important in many ways.
I think the Supreme Court became more important because it discarded fidelity to the text and started engaging in moral philosophy instead of law. And when you have 5-4 decisions on highly divisive moral questions for which there is not a good textual warrant, it makes it very divisive.
What's a good example of that decision, that type of decision?
Well, Roe versus Wade, Obergefell, the gay marriage case. Right. I don't disagree necessarily with those outcomes, but they're not within the federal authority.
So what should have happened, say, in Roe v. Wade?
Well, I think about 12 states, this was the height of the women's movement, or first wave. About 12 states, I think, had changed their laws. A few probably had considered and not done. The rest were yet to do so, yet to consider and decide what to do. And similarly with same-sex marriage, the states were going along. The Iowa Supreme Court held that it was a matter of a constitutional right under the Iowa Constitution. And at the next election, I think 3 of the 4 judges in that majority were not reelected because the people there disagreed with that. It was coming out different ways in different states. And that was not an untenable matter. But most important, it was a process that was legitimate. There's a lovely book by Marianne Glendon called Divorce and Abortion, or Abortion and Divorce in Western Law, and it's a comparative study of 23 countries. And 22 countries resolved the abortion matter by statute, and 1 by judicial fiat. And you don't see demonstrations all over the place in those 22 countries, because when there's a legislative resolution, it's not somebody wins and somebody loses, which it is in court. It's compromise is necessary.
Can I ask from a libertarian perspective, or from my understanding of libertarian perspective, we wouldn't say, in a way you're saying, okay, these really tough moral issues or cultural issues are being worked out, abortion, gay marriage, or same-sex marriage. And part of what you're saying is that it'll be worked out through legislatures, so we need to give it time to kind of find its way. But then, you think about if it was free speech, you wouldn't say, well, you know what, Iowa wants to ban certain types of free speech, well, we'll let that go because you can move to Minnesota and have free speech or something.
But it's not because of federalism and being able to move from one state to another. It's because free speech is specifically protected.
So it is. I mean, when things are enumerated, they're enumerated for a reason.
It's there. It's in the Constitution.
Yeah.
That question.
So something like abortion, something like marriage, these just don't rise. I mean, they are not something that should be decided by the federal judiciary, for the most part.
Not decided on the merits. No, they should have been. They should have said this is not a matter to which our Constitution speaks, the federal Constitution. Go home and deal with your state legislature.
What
or the state courts?
How would and I think we have a sense of it, but how would if you had been on the Supreme Court, how would a Ginsburg court have have been different than the one that we've encountered for the past 3 or 4 decades?
Well, I think I just told you at least a couple of important examples. Here's another one. About 10 years ago, in a case called Kelo against New London, the city decided to condemn property in order to turn it over to a developer for revitalization of the downtown area or the neighborhood. And Mrs. Kelo didn't want her property taken for that. Went to the Supreme Court, and the relevant provision of the Constitution says the property may be taken for a public use with just compensation. And a public use was pretty well understood. That meant a highway, a post office, a school, a public use. And the Supreme Court said, well, this is a public purpose. That's good enough. It's a public purpose. We know that because the public body, this town council, voted for it. Well, that's rewriting the Constitution. It doesn't say a public purpose.
And that's an interesting decision because it's not simply, kind of conservatives versus liberals.
About 40 states very quickly, either by statute or court decision, said, we're not doing that.
So we wouldn't have had...
Your property is secure.
But so that might not have happened, or it might not have had to have happened had you been on the Supreme Court.
Well, I certainly wouldn't have agreed with it. I don't remember if it was 5-4. I think it probably was.
To bring it back to your forthcoming series on the Constitution, A More or Less Perfect Union, personal discovery, part of what's interesting is that you talk to a lot of different types of people, both, kind of professional thinkers on the Constitution, but then regular people. What, in going through that, are you optimistic that, that we're in pretty good shape, or are you really like, oh my God, this is like, we're just screwed here?
Well, I wouldn't have made the effort if I thought it was bootless, and I wouldn't have made the effort if I thought it was needless, right? So I think I want the public, at least the public television part of the public, to be aware of a debate that's extremely important to our republic. It's a debate that occurs in law schools and on courts, and needs more public engagement, more public awareness. I don't think the public would support some of the creativity that they're getting from the courts, or some of the lassitude from the legislature, if they were more familiar with it.
What is it beyond your series? Is there a go-to text or book or document or movie that you?
Oh, Nick, I'm glad you asked that. There's a companion volume called Voices of Our Republic, which has things that people have written about the Constitution or said, mostly for the book, but some of them are a few historical quotations. Justice O'Connor, Justice Ginsburg, Justice Gorsuch, and I think a couple of others have all contributed to the book with their thoughts. And there's some material about the making of the series in there as well. So we're optimistic that will help get the message across, just as the TV show does, that this is an important topic. As Randy Barnett says in the show, the only living Constitution is one that's followed. But that name's been appropriated. So.
Well, we'll leave it there. We've been talking with Judge Douglas Ginsburg. Thank you so much.
Thank you, Nick, for having me. Appreciate it.
For Reason, I'm Nick Gillespie.